Hi,
Great.
hi team. Good afternoon. My name is Ben Mirza, and let me start the slideshow here. So I'm going to do screen share screen two, and we'll start from the beginning. So today's seminar is really intended for those who are going through probably a difficult time in figuring out what to do next, or maybe they've already entered into one or about to enter into a non-compete with their employer. And so Ed and I, we actually talk about this stuff very often, and we lose sleep over it on behalf of our clients, and we take care of our clients. And it's a pretty stressful time for them, and we feel their pain as to what they're going through. So first of all, thank you, Charles, for hosting this. Thank you to BCMA for also getting the word out to their physicians and being more involved in the community. I really appreciate Broward County Medical Association being a part of what we do. For beginners, let me start off with a little bit of introductions. Again, my name is Ben Mirza. I'm an attorney. I've been practicing for about 21, coming up on 22 years. Prior to that, I was a certified public accountant, and over the years, I did become a certified healthcare compliance officer. I was also an ISO 9000 auditor. I love collecting diplomas, degrees, licenses, certificates. I'm almost kind of a junkie in that way. But so I'm diploma rich and car poor, as they say. So, and I've got several degrees starting from accounting, because the accounting always has something to do with whatever transaction you get into. So you really got to understand how the finance and the financials flow. So that's my background in this, and we'll talk about finance and how the world of finance is affected through these non-competes today. But really, the person that I want to introduce you to is Ed Meyer. He is, I tell you, in my world, he's in the top 10 of Stark Law, Anti-Kickback, and False Claims Acts guys. He understands that stuff better than most anybody. I do, but he knows it better. He's fantastic. He is a great resource for you all to tap into, as well as myself. I tap into him all the time, and he helps me a lot on the cases that I work on. Ed, you want to?
Oh yes. Thank you, Ben.
I know I didn't get into that.
You kind of, yeah. Thank you, Ben. Again, my name is Ed Meyer. I'm of counsel to the Mirza Healthcare Law Partners. I've been practicing law for 30 years. In fact, even before I started practicing law, I worked in Washington, D.C. And for both a member of Congress on the Ways and Means Committee when they were first considering the Stark Law, and then later in the Reagan administration at the U.S. Department of Health and Human Services. My background is been representing not just representing large health systems, national physician groups. I had been with Mednex previously. Now I think they call themselves pediatrics, and as well as representing individual physicians, and mostly in their healthcare, regulatory, and business transaction area. Again, I'm licensed in California, so I focus on the federal issues for anything in Florida. And as you see with the non-competes, I'll be talking about some federal issues, as well as just general business discussions on what I've seen in healthcare on non-competes. But thank you very much, Ben. I also want to remind you all that this presentation is intended for a general informational and educational session purposes only. It's not legal advice. The seminar is open. This forum is open. It's live. It's being recorded to be used in an open platform and online resources. Ben.
We make these resources primarily available for purposes of assisting physicians, because there's a lot of financial pressures that are coming down and have been coming down over the decades, and I think right now there's even more so. So lately, there's been a big PE push. We're seeing a lot of private equity firms that are going out, they're buying up clinic after clinic, physician practice after physician practice. And what's happening is that the PE side has a very different interest, PE being private equity, has a very different interest than the physicians do. So there's an obvious rub there. The MSOs are coming into play as well. The management services organizations are coming in, and depending on what flavor you get, because there's multiple flavors of MSOs, what they're also doing is they're tying down physicians, and they're even tying. Sometimes it's even driven by the insurance contracts that they're entering into. The insurance contracts are traveling all the way through the MSOs and into the physicians, where the physicians are getting tied down. So in this world, the way things are changing is getting tougher and tighter. And today's purpose is really to help the physicians as to what they need to do.
Yeah, I don't want to mention that. I just got back from addressing the a joint meeting of the Chicago Medical Society and the American Bar Association on healthcare innovation, and there was a lot of private equity speakers on that. But it's so important. Again, it's so important to have an advocate on the physician side in these arrangements, and that's what we focus on is representing on the physician side, because oftentimes you're dealing with these large systems and large private equity firms with big sophisticated counsel, and it's just so important to make sure that the physician side is advocated for, and especially in the area of the non-compete.
True. So a couple of examples. One is something I came across not too long ago. One was actually a hospital where a physician was looking to leave a hospital and had a 5-mile radius, but they had a particular specialty. And what they wanted to do was really set up an office down the street from the hospital and just open up an office. And it was a 5-mile radius. When they came to us, we basically talked to them, and it was glaringly obvious they were going to be in violation of that 5-mile radius. So we talked about maybe doing like a step sort of a transaction where they first move out of the 5-mile radius and then back into the 5-mile radius over time. But there's different ways to like configure that sort of an arrangement, and you really have to review your non-competes in order to exactly figure out what your options are. But today, in the latter part of today's presentation, we're going to walk you through some of those techniques that some of our clients have used in the past and that have actually worked. Another scenario is a family practice clinic, having a 30-mile radius, which is really large, right? I mean, it's just really large. If you're in Broward County and you have a 30-mile radius, you pretty much have to move out of the county. I don't think that there's a corner you can hit within. Maybe diagonally across, maybe that's possible, but you pretty much have to move out of the county in order, if you've got a 30-mile radius. I've also seen it where you have a non-compete that goes down to as little as 1 mile and as big as across the country. But we'll talk about Florida law coming up, and we'll walk you through how Florida looks at these sorts of arrangements. So let's get started.
And I actually want to mention too, you mentioned like just the radius thing. Also keep in mind that what I've seen too in these non-competes, especially in the specialist position where they are moving from office to office to office, sometimes the way they're written is, a radius, but for every place of practice. So if they're, 1 day a week or 1 day a month at a place, theoretically, the other side might try to enforce it to even get a broader area. So there's a wide variety of what you see in non-competes. So it's obviously very important always to, read it before you sign it and really understand, sort of draw those circles around like where it goes.
And today we'll talk about.
Ben, there's a question that came up relating to. Can you take a quick look at it in the chat box?
Let's look at it. What is considered reasonable radius for a non-compete for South Florida orthopedic practices? I currently have one that is 20 miles from any of our 4 offices. That border, wow, that's a tough one. We're going to cover that just shortly. If that's
we're going to
okay
cover through that, talk about that.
Yeah.
Thank you for the question.
Thank you for the question. We'll definitely go through that. So just so you understand, I mean, in terms of there's market forces in place. Number one, there's the actual healthcare business itself. The non-competes are really intended to give them the edge, and the reason why they need the edge is because they've invested a lot of money in the expensive infrastructure that goes into healthcare. For example, building, technology, recruiting, marketing, patient acquisition side of it is not cheap, as we all know, and it's not easy to acquire patients, but it's a fairly expensive road to go down on. And then also from the patient's perspective, it's kind of a mixed bag. On one side, their insurance rates are lower because the providers can come in at a lower cost if their interests are protected. But at the same time, the patients somewhat lose choice as well, right? So the physician can't open up an office down the street. They literally have to like move out of that radius to get there. So, so for patients, it's mixed. When it comes to the employed physicians, it's clearly that they lose freedom. It's the commoditization of the profession. It's the restriction of their professional freedoms. And it leads to physician burnout. And they just kind of want to get done with the industry. And some of them literally have left out of state. Some of our clients in the past have left from here and out of state, and I'm talking with a few currently that are contemplating that. And it's sad, but that's what physicians are faced with. It's just a lot of pressure. And today, sorry to sound so physician-centric if any of you are business people on here, but this is really intended for the benefit of the physicians.
Yeah, one thing I was want to mention too on the non-competes, that we just talked about some of the negative aspects of it, but also when you're looking at entering into a non-compete, one thing is always to consider the valuation piece of it, because the value, as I say, if it's a practice being sold, and then they're trying to say what's fair market value for the payment to the physician, and the valuation for people looking at the value of it, maybe looking also at the value of that non-compete. So it is sort of a give and take piece. I want to make sure I add that in there, that the valuation folks may be looking at that non-compete and say that actually has a dollar value that is then inside what the compensation is to the physician. So just keep that in mind too.
Ed, and you actually bring up another really good point, because some of these practices that are getting bought out, I mean, obviously they weigh the non-competes like you said, but then there's an after effect once they get bought out by or taken over by an MSO. What happens when the business actually goes down, right? If there is an earnout in those agreements and the business actually goes down, so your heated store goes down, your revenue goes down, there's nobody answering the phones the right way, nobody doing refills properly, so the patients start to actually leave you. So in, let's say, before acquisition, it was a $5 million revenue stream, and after acquisition, it ends up being a let's say, $4 million revenue stream. Who's really responsible, especially if there's an earnout in that situation, right? So some MSOs, some buyouts can lead to negative outcomes. They aren't always positive, and if there's an earnout at the end of it, you have to be careful. Anyway, I'll get off that mic and move on to the next point, which is today. First, we're going to cover some of these technicalities that you really have to understand in order to navigate the space. We're going to talk about non-competes and restrictive covenants and how those differ and what they exactly mean in the legal world, because they're not the same thing. We'll talk about Florida case law. We'll talk about the statutes that govern physician restrictive covenants. We'll talk about the sale of a practice and the effect of on restrictive covenants. So, like, what happens once you sell a practice? Do you really have to abide by the same non-compete that you signed before the acquisition? And last but not least, we're going to walk you through a checklist of negotiations. This is where what we're building up towards. So once you kind of figure out bullet point number 1, 2, and 3, number 4 is where we walk you through what are you going to be negotiating? When do you know that you've got the ability to do something or not? And so we're going to help you be able to hopefully help yourself for the most part. And if you need us, then you call us. But for the most part, our intention here is to make you as capable as we can within the next 45 minutes to get there. So, so starting off with restrictive covenants. Ed, you want to cover this, or you want me to do it?
Well, let you cover that, and then I'll add some commentary to it.
Yeah. So here we go. So as far as restrictive covenants go, the words themselves are much broader than a non-compete agreement, right? The restrictive covenants really could apply to a lot of different types of agreements. It could apply to like deeds and easements. You have restrictive covenants to deeds, restrictive covenants to easements, restrictive covenants to like trade contracts, software licensing, debt contracts. It just goes on and on. I mean, the list is pretty big. So restrictive covenant is a very broad term, but
And I want to mention too that a non-compete is a type of restrictive covenant. There are other restricted covenants you'll commonly see in employment contracts, such as the non-solicitation provision, non-solicitation of employees, the non-use, confidentiality of information, non-solicitation of customers and patients, and those restricted covenants we're going to talk a little about later because they actually come into play in the federal U.S. Department of Justice viewpoint on these long-term post-employment non-competes and whether or not they would find them supportable.
Do you mind explaining what a non-solicitation of an employee versus a patient, how that works? Like, what does that mean?
Okay, yeah. So oftentimes they'll when you look at your employment contract, you'll see if you have the restricted covenant provisions, there'll be a non-compete. Then there'll be something that says that you cannot solicit during the term or some period afterwards. You cannot solicit the employees. So if you're leaving the employment or while you're employed, you can't say, "Oh, hey, other employees, other physicians, join me in a new practice," or other other employees of the group. Non-solicit, and also sometimes you see these non-solicitation provisions dealing in contracts dealing with non-solicitation of the other side. So if like a coverage agreement, sometimes you'll see this issue of non-solicitation of the employees of the hospital. You can't try to get them to come to work for you all. And those provisions obviously need to be very narrowly tailored because there's some antitrust issues we call the anti-poaching provisions where the antitrust people are really focused on the ability of people to freely move around and work and not having provisions that restrict people's employment. And that's one of the things that they've actually had cases in there was a case in North Carolina, a federal case dealing with Duke University and the University of North Carolina, where they basically had agreed amongst themselves that they wouldn't hire each other's physicians. And the federal government said, no, that's anti-poaching. You can't have a provision like that. Now, non-solicitation of patients, there's like, you can't solicit, you can't say, I'm going to go to a practice and then start hitting up the other patients in there or other customers or other vendors that they use. You see those provisions also in employment contracts.
That's a non-solicitation component. And then there's the confidentiality of information. And I think we've got a lot of ground to cover. So we're going to kind of speed this up a little bit.
Okay.
So when it comes to actually non-competes, remember, there's going to be several things that every non-compete hinges upon. It hinges upon the medical specialty that's labeled in the contract. That's hugely important. So like, for example, if you have a dual specialty and you're a pulmonary and an ICU sort of a person, then pick your specialty when you actually look at a contract. Also, geography matters. Geography, where that's going to be another limiting factor for you. And then the specific patient base. Sometimes they'll say you can't go after any Medicare Advantage patients, or you can't go after like a particular sort of a population, and you can see that. And then a non-poaching, like Ed had just mentioned. So we're going to walk you through some of that. But starting off with Florida Statute 542-335, this is a really big one in this world, and all litigation starts off with this particular statute. So when the way the courts look at it is, number one, is there a legitimate business interest? And when there's a legitimate business interest, they really look at the special facts of the case, meaning like, is there something of real concern that is that's at issue that the person could be walking away from? What they're going to look at is to see if the employee would gain an unfair advantage by leaving the practice and moving along and doing and violating, let's say, that non-compete covenant. Do they gain anything? If they gain something out of it, and they gain an unfair advantage, it's going to be problematic. And then also the restriction has to be reasonable as to time, area, and line of business. So what that is anybody's guess at this stage. But remember, it gets litigated. So I think somebody had asked about, what about 20 miles? Well, it's going to depend on your area of practice, and also it's going to be affected by your geography. You know, geography of 20 miles in Broward County is very different than it would be like if you're like in the middle of the state, like Ocala or Lake City or something like that. And then last but
And
not
if it's,
least,
when we say it was 20 miles, and it was kind of getting back to that question I pulled up. If it's 20 miles from any office and they never practice at any of the offices, and you're not dealing with a non-compete in the sale of a business, but it's just an employee in any of their offices, you know, that could be, you know, that's questionable on whether it's actually even reasonable if that physician never even is even at that location.
so and then last but not least, every restrictive covenant, in order to be enforceable, has to be in writing. It has to be signed. If it's not signed, it's not enforceable. So if you have a non-compete that you were handed, but you never signed it, now, you know, you've got a pretty good basis for saying element number 4 is not met. But that doesn't necessarily mean that your former employer may not come after you. It just means that the 4th element has not been met. Chances are you're on the prevailing side. But, you know, this is America. Anyone can sue anybody. So also keep in mind that the statute specifically states that if you argue undue hardship, unlike California and perhaps some of the other states, and Ed could speak of that, you know, Florida specifically states that you cannot take an individual person's economic hardship that they would be going through if they are restricted from practicing, let's say, 5 miles down the road. Those economic hardships are not considered by the court, and the statute says, hey, court, you cannot listen to those hardship situations, which is what's really on the opposite end of the spectrum as compared to Ed. You want to talk a little bit about what's going on in the other states?
Well, yeah, no, I mentioned in so in California, the non-compete, you really cannot, unless it's part of a non-compete that's part of a sale of a business, a practice, you really can't have a non-compete in a physician group, in a physician employment agreement. You know, I know a lot about Texas. You can have a physician non-competes they can have them in there, but there has to be certain provisions and also must be in the Texas non-compete provisions in an employment agreement with a physician, including the ability to have a buyout of the non-compete and the ability to have access to medical records upon departure, to be able to notify patients of your departure. There's things like that in other states. So every state, the point I want to make is every state has its own sort of nuance on the enforceability of a non-compete, because there's a lot of it's a state issue, but I'll also talk in a minute about federal issues with non-competes.
By the way, just so you're aware of it, there is a statute in the state of Florida which basically says that, you know, if there is if there's only one entity inside a county and it's got a restrictive covenant for you not to be allowed to practice within the same county, that's not a legitimate business interest. Like, for example, that specifically happened in this next case that we're going to talk about, which is the 21st Century Oncology versus Moody. That's where the court found that because a physician is a specialist, they're in a rural county, and all specialists in that county are employed by the same individual, single employer. They had all signed non-competes that say you cannot work in the county for anybody else. So that also meant that they could not go out and work on their own, and the courts held that to be improper. But Florida courts are a little bit different at the same time, and we'll talk about what's called the blue pencil law in just a little bit. So moving on to the next point. One is, in this case, this is like dating back to the 1990s. In the mid to late 1990s, there was a case of Humana versus Ira Jacobson. You might know Ira Jacobson, some of you that are on here, because he is a local physician, or was a local physician. I believe he's still practicing today. And what happened there was what the courts found is that the HMOs do not own the patients, that the patients have the right to go to their physician. If the patients choose to go to their own physician whenever they want, it's their entire right, right? It's kind of like choosing your preacher, choosing your lawyer. You have the right to go and do that. However, Florida still can restrict you if you go after the patient as a physician. So physicians chasing patients, that could still be improper, but patients coming after physicians unsolicited is fine and dandy, which is what this case said. Now, the only unique thing that you need to consider here is this is Humana versus a physician, right? So Humana is different than a practice going after another physician. So that still has not been tested at the appellate court levels. It has been tested in courthouses, but those are usually settled out and they're dealt with very differently. But keep this in mind that a patient has a right to choose their physician. And another thing to keep in mind is a lot of times we hear in Florida, and I'm sure Ed's got some stuff to put in on this one, is that if a ongoing and continuing employee while they're working is handed a non-compete to sign during the time of their employment, this is the myth. This is the myth in Florida, which is that if the physician signs off on that non-compete during the period of employment, that it's really invalid, that it wasn't an equal bargaining table. So if it's not an equal bargaining table, when they sign off on it, it's deemed to be that they were coerced into it. Well, that law is pretty well established in Florida now. What the courts have found is that Florida is an at-will state. Anybody can quit and anybody can get fired at any time. So if you want to continue your employment and you have to sign this agreement, well, each side is making a legitimate promise. There's adequate consideration from both sides that's being given, and that you're going to have that they're going to. It would be deemed proper to have them sign a restrictive covenant in the middle of their employment. Ed, you want to add something to that one?
Yeah, I'll add sort of California nuance. Again, like I've said, let's say you're in California and you're employed as a physician. One, as I said already, you can't really have a non-compete. But let's say you're dealing with the non-physician employees of it, and they're already employed. They don't have non-competes, and you then want to add an amendment to that, a non-compete. In California, you'd have to have additional consideration for that. Otherwise, California wouldn't and would not enforce it. So, again, this all deals with the fact that every state's a little bit different on all these issues of non-competes and how they're enforced and when you could add them and how you could add them. So it's just very important to just really focus on the state law.
Ed, I think
Yeah, and I actually want to talk about. I want to mention this because we've been talking about, or Ben has been talking about Florida state law issues, and I mentioned some other state laws and how each state is a little bit different. But there is this potential push you may be seeing in the next couple of years by the federal Justice Department. And in the Biden administration, about a year and a half ago, President Biden signed an executive order telling the different government agencies to, look at the federal antitrust laws with regard to ensuring that we have better competition within the country, and especially in the area of employment. And there's this case, it was a Nevada case dealing, it wasn't a federal case, it was a Nevada case dealing with a physician who had signed a non-compete and was attempting to get out of the non-compete with his medical group called Pickett Medical Group, and it was being litigated. And the federal antitrust folks filed, it's called a statement of interest. It was like an amicus brief, not a party to it, but they basically were informing the judge, this is how the federal government looks at these non-competes, especially these non-competes specifically on post-employment. You can't work for a couple of years after. You can't compete for a couple of years after you terminate employment. They looked at this and said, hey, look, you have to, from the federal point of view, physicians who are joining a practice, and that practice may be potential competitors, because the practice provides a service. The physician in private practice provides the same service. And when they join together, they have two competitors or potential competitors agreeing to on a restraint, which is a non-compete. The Sherman Act, the Federal Antitrust Act, prohibits unreasonable restraints of trade, agreements between competitors that will stifle competition. So they looked at this and they told the court, hey, court, this particular post-employment non-compete, which was actually went for, effectively was a 9-year non-compete, meaning that it was a non-compete that was 7 years while they're employed, and if it was the employment was for 7 years, the contracts for 7 years. I think it even dealt with an acquisition where they had a non-compete that ran for a term of 7 years, and then when they left, they had 2 more years. They couldn't compete that, so it's 9 years. And they really said, look, that's especially when they, like I mentioned, the other restrictive covenants, the federal court was telling, and the federal justice court was telling the state court that, look, you got other restrictions that protect the interests of the employer. You have the non-solicitation of employees, the non-solicitation of vendors and customers, the requirement that keep the employer's information confidential, and that are indication that this particular restraint may not be reasonable. And what basically, if it was an unreasonable restraint of trade, and you can't find a pro-competitive reasons that outweigh the restraint, then it would be unenforceable. In fact, they alluded to what's called a per se violation, that agreements between competitors to divide up a market is a per se violation. So they sprinkled their discussion on that per se issue, but they never really got to it. Bottom line is the employer bears on a federal case, the challenge of it. The employer bears the burden of demonstrating that the restraint is reasonable, necessary to protect their legitimate business interests. So the point I want to make is, again, this is just a filing that they made to court to inform the court on what their position is. I do see that you may see down the line a more formal action by the federal antitrust folks seeking to challenge non-competes in the physician area. So we just keep a watch out for that. Or we'll be keeping a watch out for it also, by the way.
What are your thoughts on mergers and acquisitions and how they're affected by non-competes?
Yeah, I think that Pickard thing. In fact, I mentioned I was in Chicago, and at the joint meeting of the American Bar Association Health Law Section and the Chicago Medical Society, and there was a lot of private equity folks, speakers on the private equity side, saying that. I've asked this, and I've asked at other conferences I've been, have you guys looked at this Pickard Medical Group case? And a lot of them are like, well, no, we really know, we haven't looked at it. So I think that's sort of a blind side that's in the acquisition side on potential risk for those who are acquiring groups and acquiring and putting these non-competes in, especially if they go for long term, and then they're 7 years of employment, and then 2 years after you leave employment, that you can't compete. So it's like 9 years of not competing. I believe that you might see some work on that might affect the whole mergers and acquisitions area of practices.
So a couple of things to keep in mind is that when it comes to a sale of a practice, there's 2 ways it happens. One is it could be an asset sale, and the other one is that it could be a merger, right? So where an asset sale would be where the entity sells off all of its assets, right? So the assets are anything that's a positive, not the liability side of it, just the positive side of it. That could include the patient custody of the patient list. That could include the physician contracts. That could include the revenue side of the contracts, as the asset it would be assigned with the sale. Now, in a merger, it's much cleaner and clearer that everything that was happening in the target is assumed into the parent once it's acquired. So you really have to look at the assignment clauses within the employment agreement to figure out what's going to happen. And then you also have to look at the actual transaction as to what happened there, what contracts were specifically assigned, to figure out whether that non-compete traveled from employer number 1 over to employer number 2 who acquired them.
Yeah, I mean, look at the assignment clauses, because y'all may have these non-competes. So I'm really comfortable with my employer, but that employer could sell, and then you don't know who they're selling to, and they sell to someone. You go, well, I don't want to deal with this type of company. Let's say you're in a nonprofit, and then you go, I don't want to. Also, they sell to a for-profit. Likely that person, that entity. If it's a merger, or if the assignment allows the employer to just sign it, then you're under that non-compete with a new employer. So it's really important to look at the language.
Let's talk a little bit about when it comes time to negotiate a non-compete, what are the terms you're going to be negotiating over? Number one, everybody looks at the actual actual geographical limits, right? But Ed had made a really good point earlier, which is sometimes it's from any entity that belongs to that institution that you can't be, let's say, within 10 miles of that. When really, in fact, you're in, let's say, one location, not all the locations. You only got exposed to the patients that surrounded that area, not like all the ones that were in the, let's say, the neighboring county. So, the geographical limits really do matter. And one of the ways to actually curtail that is to say, wherever you were in the trailing 12 months is the way to curtail it, or the trailing 6 months, or the trailing 24 months. But a trailing 12 months is like a good way to do it, to say wherever the physician was working for the last 12 months is where we're going to take our radius from, not from any place that they've worked in totality. So like, for example, you could start off working, down in Miami, they move you up to Broward, and then they move you up to Palm Beach County. Now you've been in 3 different locations. And if you've got to be, 10 miles away from that, my God, these 3 counties, you're going to have a hard time with it. Staying out of range on that 10-mile radius.
Right. And it's actually worked, and you would add like the number of hours, actually put in on average the 30, 40 hours a week, right? Not just say they sent you over to a location, you're in Broward, they send you over down to Miami or something, and for a day. And I was like, oh, now it applies. No. You want to make sure that there's an hour restriction on it.
Yeah, that would obviously fall into the whole 12 months thing. If they sent you down to Miami for a day, they would fall within your 12 months. But if you only did 8 hours there in the last year, does it really apply? I mean,
that's why you want to put down in the provision the number of hours. Say, what I spent substantial time at a location for during the last 12 months.
And the other thing to look for is making sure that the time frame of that restriction is fair. Typically 2 years or less is good. I've seen it shorter, I've seen it longer, but 2 years is actually a general rule of thumb that most attorneys go by. Most attorneys in this sector and space, that's what they go by, is the 2-year mark. I've seen 3 years. I don't let any of my clients go over 3 years. It's just, I think it's too long. I think it's just, waiting to get rewritten. The other thing to keep in mind is you want to review the assignment clause, and you also want to make sure that your scope of services is very specific to the actual work you're going to be doing. Like if you go in and you're doing a very specific and a narrow area of medicine, that it only applies to that. So that way, if tomorrow you get hired on for a different specialty down the street for something else, that now you're practicing something completely different. It's not what it was before. So you want to make sure that the scope of services is very specific. Another consideration is you might want to think about a buyout in your non-compete. Some people have actually entered into non-competes where they say, I'll pay $50,000 to buy my freedom back, or I'll pay $250,000 to buy my freedom. Meaning that if they leave the practice and they want to open up an office right down the street, they know they're going to be in violation of that non-compete. So what they say is, look, I'll give them cash. If I'm going to go and walk away and be in competition with them, I'll give them money just to resolve it. So all they do is they actually cut a check and call it a day. They don't have to do anything else. So you can have a buyout provision right within your contract. Anything else, Ed?
What I was saying, I saw there was a question in the chat room, is how long, if you're start employment and they want to add this non-compete, how long do you have before they can fire you? It's really just that's a business issue that they have between the employer. If you're at will, then they could always fire you, right? I don't think that
Yeah,
there's
no,
any sort of
And
statutory time frame on it. It's just, you just gotta
we are
careful.
an at-will state, so yeah, it's really a business decision. By the way, if you notice this, this particular slide has in it a camera, right? A click. This is probably one of those slides that you do want to take a picture of, so you know you've got it for your records and you have it handy as to what you're looking
Think
for.
about that. Yeah.
Ben, I got a
Wait,
quick question for you, Ben.
sure.
So we talk about geographic areas relating to miles and cities and states or whatever. What about telehealth? Has that ever come up where your doctors work in the telehealth type business and you know, what's the non-compete restriction there?
You know, I haven't seen one litigated, but I've negotiated a few of them. It just basically says that you're not going to go work directly for a competitor in telehealth, which is again a very broad area, right? So like you could have a I don't know, Teledoc and everybody else, right? I mean, there's a bunch of them that are out there, and they're saying you can't go work for a competitor. I've seen that very often in these telehealth agreements, but I have not seen it litigated yet. So Charles, that's a great question. I'm
Yeah,
looking
we're
forward
working for a
to
competitor versus geographic area because I think, you know, this the telehealth is new, right? And so the real question is like, do the patients even know who the physician is in the telehealth area? You know, because they're just like bringing them remotely. It depends. So it's a new area. It's a new area. So um, you would want to be very careful when you enter into them that to look at it and not and making sure that it's not as broad as you think. So always think of if you left, where can you work and what can you do? That's there. You're not restricted. And just again, it's so important to look at these things before you sign them. But we'll talk a little bit about in a moment. Ben will talk about ways around them when you have.
All right. So the next question that comes to me is, when a physician approaches me, and by the way, this is another one of those slides that I think you should take a picture of, and keep it because you're going to need it when it's the right time. So physicians will come to me and they'll be like, you know what, my moving radius is like 50 miles, and you know, why can I not, you know, like this is just wrong. I can't believe it, blah. And they're just hating that situation. But then I ask them about what are the obligations of the employer? Well, the employer certainly has certain obligations, right? The employer has an obligation to relay messages from patients. What happens if you don't get proper relaying of messages? How many of your phone systems and the phone trees are broken down? Like the messages don't make it from the call center to your office and over to you. How many days does it take for that to actually travel over? When you know, that's, to me, that affects, number one, patient care. It's your professional obligation. It's the employer's responsibility to make sure that those systems are connected and they're working and the messages are getting conveyed over. The other thing is like the prescription reordering. How often is it that you found that, you know, the reordering system is like broken, the refilling system is broken within your organization? Many organizations have that broken. I'm not talking about anybody unique. And that's an employer's responsibility to make sure that the refilling the system is actually working. Like you're off, you know, the request comes in from the patient, somebody sitting at the desk is collecting the information, then it's coming over to you to approve and sign off on a refill. And is that happening in a timely way? Because you don't want to be the person held responsible for sending patients to the hospital. You know, that's an employer obligation where the breakdown in communication happens in a different way. The other thing is the coordination of patient services. These employers are also responsible for, some of them are, not all of them, but some of them are responsible for coordination of patient services. If the referrals aren't getting worked out the right way, you know, and it's affecting patient care, I think you as a physician have a gripe with the employer. And those to me are all breaches. I would start looking at those very, very carefully. And then bullet point number 4, where it says accurate record keeping. How many of you have actually gone to your employer and asked them, can I get a billing report with my NPI number on it? And the answer is, of course you can. 2 weeks later, you ask for it again. And they say, oh, let me get back to you. And then 2 weeks later, again, you ask for your billing report with the NPI number. And guess what? Then they come back to you and they say, oh, sorry, the system just doesn't collect it that way. Well, isn't that a bit of a breach? Because if I'm a physician, I need to know where my NPI number is getting used. It's a transparency issue. It's like a due diligence issue. You've got to know what's going on with your patients. It's highly important. The other thing that you also want to look at is where are they billing you from? What location? Is it the right location? If they have multiple locations, are they billing you from the right location? Because let me tell you, this happens. You could be working in location A and they're billing you from location B. Location B might be a higher, what do you call it?
Modifying, yeah.
What's that, Ed?
Oh, a modifier, something like that. Oh, you have
Yeah,
a
the
higher rate.
modifier. Yeah. The location could be the right modifier where they get a higher reimbursement rate. And guess what? These MBAs don't know any different. It's really the physicians whose neck is on the line, whose NPI number is getting used. The MBAs don't know squat. Don't listen to those MBA types. At the end of the day, it's your personal license that's on the line. That concerns me greatly. Also, I want to know as a physician inside a practice, I want to know if my patients are coming in and they're getting ancillary services. So like, I don't know, maybe they go and get like, an EKG, or they go get some other sort of therapy in the practice, or like allergy testing or something. Well, are they getting that? And is that getting recorded? And whose NPI number is that showing up under? Because obviously you didn't perform the services, but it's your patient, right? That's how you figure out what your actual value is to the practice, because you've attracted all these people, right? You've attracted these people, and they mean not only the services that you give them, but everybody else. It may be a cardiologist or a GI within the same practice. Well, they're also billing out, but they're not the primary. You may be the primary. So you got to figure that sort of stuff out. And if you happen to be a big referral source inside your group, it's important to understand where you are in the world and where your space is. So again, take a picture of this. I'm going to count up to 5 and then we're moving on. So Ed, anything else you want to add to this slide?
No, I don't, but I did see there was another comment in the chat room. Does a non-compete for practicing especially apply to taking call at a hospital or operating at a surgery center, or does the restrictive covenant have to specify have specific language to prohibit these 2 areas? And I think you'd have to look at the actual language itself and how it's drafted, because what it's doing is it's drafted to protect the employer, and where the employer
Do you have a sharpener?
what was that? Or is that someone just talking? Okay. Yeah, it's drafted to protect the employer. So you'd have to look at it very carefully on that. I can't tell you without looking at the real agreement, but you'd have to look at the actual contract and the language. But again, it's usually drafted as within a certain area of where you've worked for the employer, and so it would most likely be broad enough, depending upon how it's drafted, to cover those other areas.
Always go back to the actual draft of the language, and you got to read that in the context where you work.
Yeah. So again, if one's thinking about working, just for an employer, but also like moonlighting at these other locations, then you'd want to make sure you know that beforehand when you're drafting it, so that the attorneys know it beforehand, so they're very careful of how they draft these things.
So now let's talk about what's beyond the contract, because the contract is the contract, and we've beat the contract a lot. But you got to go beyond the contract. If you're going to think outside the box and you're thinking about moving and you're thinking about doing something else, first of all, I mean, obviously you're going to start with a language like what Ed just said in your contract, but then do remember that there is an ethical and a statutory requirement that the notice that if the medical records are moving from one office to another office, that the patient has to be notified as to where they can obtain their patient records. So I don't know if that helps you. Maybe it does, maybe it doesn't. But what I do know helps you is the next 2 items. So take a picture of this as well. Social media will help you, believe it or not. your own website will help you, believe it or not. So this is what happens. You can go on Facebook, you can go on LinkedIn. The more patients that are linked to you on Facebook and LinkedIn, the more they know where you are and what you're up to, right? So if you happen to move and you've got this whole non-compete agreement that you cannot violate, right? You can't go after former patients and you can't go after your referring physicians, now what you have is you've actually indirectly notified the world as to where you are, because your social media presence will tell them. It'll be on Facebook, it'll be on LinkedIn. If they're really looking for you and they really want to follow you, they'll find you. The other thing to keep in mind is keeping a website. So like, for example, if I was a doctor, I'd maybe call it something like Dr. Ben or Dr. Ben Advisory, .com. And you know what? Make sure that your patients know about it. And if your patients know about it, when it's time to move, then you move. But it's already showing up on that website, and it's your own website. If somebody types in, like, for example, Edward Meyer, Dr. Edward Meyer, would they be able to find that? Does it show up on Google? Well, heck, it's your own personal website. Nobody can stop you from it. They'd have to create a lot of other things to stop you from it. But, this is your own world. There's a whole life outside of work. The other thing to keep in mind, and I think it's sometimes overlooked, is general advertisement. So like, for example, if you know that your patients are reading a particular type of journal, then your referral sources, like for example, your referral sources may very well be reading South Florida Hospital News. If you announce in there as to where you are, that's just a general announcement or an advertisement that you just took out in the South Florida Hospital News. In the same way, you can use bus benches across the street from the practice that it's at. So all you have to do is put your picture on there, tell them where you're at. As soon as a patient comes in from the right or comes in from the left, they see benches on both sides of the street. Bus benches are fairly cheap. They're fairly inexpensive on like a per month basis. I think it's like a nice way to run an ad for a few months and maybe a whole year. And it's a nice way to pick them back up again. Advertising in local papers, getting yourself on Google, getting yourself on Bing, it all matters. So here's another way to go beyond the contract, and you've actually not violated the contract. You still moved out of your radius. You still did your things, but now your patients know where to find you.
And you're not directly soliciting patients. No, you're going to clarify is, your contract says 10 miles from the practice location and no direct solicitation of patients, right? Well, if you're doing these things, you're not directly soliciting patients, just informing the public where you are, and the patients happen to see, that park bench, across the street with your new location outside of that particular radius.
Yeah, and I think this is very valuable. I sat down with a particular physician with the BCMA one night, and then Ed and I were talking, and then between Ed and this physician at the BCMA, we came up with like a list of like what you can do as a physician to kind of get around it and get your freedom back. This is a way to get your freedom back. Now, last but not least, this is our last actual slide. There are 7 ways to fight non-compete agreements, right? So one is one of your defenses is going to be that the employer breached. That's why it's important to take a picture of that earlier slide that I sent you, and know how and what your employer's obligations are to you. So you got to put them in breach. If your employer tomorrow decides to wake up and come after you, you've got to have a defense. And what you're going to do is you're going to make sure that you're able to show the court, the judge, how your employer just did a disservice to your patients and did a disservice and lack of transparency to you. And you don't know what kind of numbers are being rolled out under your NPI number. And, you've got to hold your employer's accountable, and that's the point of bullet point number 1. The other thing you can actually fight them on is legitimate business interest. That is a much longer road to haul. If you're going to argue no legitimate business interest, you got to bring in consultants. It's an expensive battle. Litigating non-competes is really an expensive battle overall. Going back and forth in the beginning, which is how majority of the non-competes go, is not as expensive. But once it hits litigation, it is there. You can argue over geography, you can argue over scope of work or the specialty, and you can also argue public interest. Is it in the public interest to enforce that non-compete or not? But keep in mind, and I put a double asterisk next to this one, but note, Florida courts will rewrite, or what they call blue pencil, the non-compete agreement. And what does that mean? That means that a judge has a right to go and rewrite that clause. They can revise the non-compete to be what's reasonable. And I tell you, I mean, what is reasonable, right? And I'm sure you've heard that before. And judges vary on that considerably. So it's a wild card guess. So thus litigation may be on your whole litigation may be all about how you're going to revise that non-compete and make it more amenable to both sides, and the judge has to buy into it. So that's one thing. I was going to say something else. Oh yeah, not too long ago, I was speaking with a CEO of a particular health system, and large size health system, and the CEO basically said, I asked him, what's your thoughts on litigating non-competes? And there's some, I got some insight into that from having that conversation. And I've asked this question over the years, and the answers are usually pretty similar. They don't like to do non-compete litigation. And there are two reasons for that. Number one, if you litigate non-compete and you lose as an employer on a particular clause and it shows up in court, then your 10,000 employees know now that non-compete clause in your non-compete agreement is invalid, if it's the same clause, that is. And it's not hard to figure that out. You can easily look it up in the court system, which is why a lot of these non-competes are actually taken before arbitration. But a fair amount of them are also litigated in court. Number two, so the CEO's answer was, I don't want to lose in public because that's going to be problematic. And number two is the employee may have a comeback, meaning a counterclaim against the actual hospital or against the large size employer, which leads to all kinds of other problems. I mean, Ed and I, we sit on, we've got key TAM issues that we deal with pretty regularly, where the employee is now disgruntled because the employer has sued the employee, and now they're filing lawsuits against them. And the Department of Justice gets involved, a whole investigation happens, and the employers are like, hey, that physician can go and do whatever they want to do. I don't want to fight them. That's not to say that they can't sue you. That's, they will always threaten you. They will always tell you can't do it. But when it comes time to sue, who's really going to sue you? And that's a wild card. I'd hate to guess at it. I've been wrong before on it. I've been right on it as well, both ways. But you just don't know. It is a wild card.
You had one other question that came in from DG. Can you see it in the chat?
Sure. Let me look it up. If you provide referring providers with your new contact information, is that considered solicitation? It depends on the agreement and how it's written. If the non-solicitation is only as to patients or employees, that's one thing. But if it's also as to referring sources, yeah, that's problematic. That's problematic. So yeah, that's a good question, and you'd have to actually tread carefully through that if you have that in your non-solicitation provision of that agreement. Anything else you'd add to that, Ed?
No, I think I would concur with that. You think about other ways around it, making a general announcement in the newspaper that Dr. F, ABC is now with this other location in a publication that your referring physicians would normally read. So you're not really soliciting them, but you're giving out general information and put the new contact information. So that's all kind of the way around it.
So if you're dealing with a provision and you're having a hard time trying to figure out what it is, and hopefully we've shed we've shed some level of light for you. And the answers aren't always that clear. And even if you get them reviewed by different attorneys, the answers may still not be all that clear. And remember, this is America. Anyone has a right to sue anybody. But if you want to get something reviewed by us, you're welcome to call us or email us, either one of us. Send us the actual document that you want us to look at, because that always helps. And we get a cursory look at it before we even speak with you and give you an idea of what we're seeing. And we can, we're happy to give you, free legal advices to the extent that we can. And hopefully we'll help you resolve your legal issues. So that's the way to get a hold of us. If you take a picture of this, it has obviously our phone numbers and our email addresses on it. You're welcome to call or text either one of us, and we'll take it from there. So that's all we have for today.
Yeah, the other thing is that if you wanted to revisit this video within the next couple of days, it'll be up on the South Florida Hospital News site, and there'll be a link on Ben's site for it. You'll be able to do it. If you have other people that you think may benefit from this, you can send them to the South Florida Hospital News website under webinars, and you'll be able to find this along with the other webinars that we've done throughout the last couple of years. So with that, any final remarks, Ben or Ed?
Thank you. Thank you for staying with us all during this presentation. We hope you found it helpful for yourself. And bottom line is, before you sign one, look at it. Have an attorney look at it very carefully. But if you're already in one, you can still think about ways to work around them.
Great. All right. With that, I want to thank everybody for joining us. We will have another webinar. It should see in the newsletter. I'm sure you're getting the newsletter. It's in October. I think it's October 18th. Is that correct?
Yeah, it's on October 18th. You know what? I'd have to look up exactly what it is, Charles. I don't remember.
But it's definitely October 18th. So mark the count for October 18th at 6:30, and you'll be able to see that again in the newsletter that comes out on Thursday, and be able to register early for it. So once again, thank you for joining the Mirza Law Group, South Florida Hospital News, and we'll see you next time. Take care. Bye-bye.
Thanks. Take care.
Bye, Joe.